To be able to have a False Claims Act case, a whistleblower really needs to have certain kinds of information to qualify under the statute. First and foremost, the information has to not be publicly disclosed. In other words, it needs to really be original information that the whistleblower is bringing to the government as an original source. For example, this can be where a bookkeeper inside of a company sees some improper billing going on. It can be, for example, a CFO who may have knowledge. It could even be someone, for example, who is aware of something that's related to a government contract that's fraudulent, or for example, where a company is claiming improper qualifications for a government contract. There's really a whole wide variety and spectrum of the nature that a False Claims Act can be. If it's something that's improper, that's false, that's fraudulent, a lot of those types of allegations can be the basis. But at its core, though, it has to be original information that's not been in the public. For example, hasn't been in the news media, hasn't been broadcast, hasn't been made public. It has to be original information that the whistleblower came about through their own firsthand knowledge. It can be secondhand under certain circumstances, but certainly the whistleblower has to have original information that's going to bring to the government. So that's number one. Second of all, there's actually a bar. There's a statutory bar that if the whistleblower isn't the first to file, then they're going to be prohibited from being a relator under the False Claims Act case. This means, for example, let's say sometimes there are numerous people who may know about a particular fraudulent activity. If person A, the first whistleblower files under seal, presents it to the government, files under seal, that person actually has the claim. If then a second or third person come along and then also file a complaint under seal, then they will not be a valid whistleblower according to the statute. It's just that first person. So it has to be original information, first to file. And then another third big criteria that seems to be a problem or a hurdle for some whistleblowers is that the information isn't specific enough. The information provided by the whistleblower really has to be sufficient that a case under the False Claims Act can be proven in a court of law. The government has a burden of proof, or the whistleblower standing in the shoes of the government will have a burden of proof. So there has to be enough information to be able to prove the specifics of what happened. And some of the ways that the evidence can fail is, for example, if there's not proof of sufficient what they call scienter, which is it's a form of knowledge, and there's legal standards that apply to that. But sometimes if it's just a vague idea of what may have happened and it's not sufficient to prove that the company or the individual actually knew about it, that can be a problem under certain circumstances. And I'm probably oversimplifying this, but it does sometimes get very detailed in terms of when a claim can or cannot be enough under the various standards of law. There's also another body of case law dealing with proof of the specific claim itself. There's actually a rule, it's 9B under the Rules of Procedure, that talks about the whistleblower needing to present sufficient evidence of the specific claim itself and the presentment of that claim to the government to be able to qualify under the False Claims Act. Now, I know this is kind of getting in the weeds, and this is really where some of the assistance of a lawyer can be very helpful, because it's really in the details sometimes that the difference can be between a False Claims Act case being able to proceed on the merits and not proceed because it simply doesn't meet the various legal requirements that the courts have recognized have to be satisfied by the evidence in a case. So long story short, though, if there's meaningful evidence of a significant False Claims Act, that's why it's a good idea to obtain an attorney who can actually give you advice on these kind of things. But certainly you need to be the first to file, you need to have an original source, and the more information about the specifics of what happened is always better, because at the end of the day, the government has a burden of proof, and as the whistleblower, as the relator, it's your responsibility to be a partner with the Department of Justice in prosecuting and proving the false claim.